Good morning. We're going to talk about imprisonment for debt and what creditors can do to use this powerful remedy to collect. Okay. So most people today think that imprisonment for debt is unconstitutional and is no longer permitted. It's a relic of the 18th century, 19th century. So how did they get to this point? I think considering history is going to be interesting because it's so different than today, and that's really what led to the people's perception that it was no longer possible. For example, in the ancient world in Rome, failure to pay a debt led you to be able to sell your son to the creditor as a slave. Additionally, this remedy was also possible if you were a judgment debtor. A tortfeasor was able to sell his firstborn male son to avoid having the judgment collected against him. And as we progressed, other remedies like military service and excommunication, so both here in this world and here and after, debtors were punished quite severely. In early England, they made a distinction between the common and civil and criminal law, rather, and arrest was originally prohibited for civil matters. However, the situation changed dramatically, and by essentially the 16th century, any possible action that could lead to a judgment, that is, could lead to the arrest of the debtor. So there was basically when the U.S. colonies were founded, in England at the time, you could basically be held without any kind of judgment or any kind of hearing at all for debt. Various protections were added over the years, but it was still common until the 19th century to have people in prison for 20 or 30 years without any the debt changing at all, or without any really judgment other than the fact that they owed money 30 years ago. And we see reform movements in the United States. So the U.S. was always a little bit different because in certain colonies, people who were debtors were encouraged to move, like Georgia, for example, never had any kind of imprisonment for debt from its earliest days. But you see, most of the major concern occurred in the 1820s and 1830s. North Carolina, for example, prohibited the use of imprisonment for debt for women in 1823 and added additional protections for poor men. But men were not finally free from the possibility of imprisonment, or the theoretical possibility of imprisonment, until 1844. And you see similar actions happening all across the country at this time. So the federal government stopped imprisoning debtors in 1827. See, Mason versus Hale was the important case there. And essentially, all the reforms took place. So before the Civil War, the law was, in every state, theoretically, the debtor could no longer be arrested. Okay. And now we're going to show a short video of what kind of a transaction that can lead to imprisonment for debt today, in spite of these prohibitions.
So, as Harrison mentioned, the early 19th century brought a wave of various restrictions on and prohibitions on imprisonment for debt. Little has changed since then, hence the modern perception that you simply can't put somebody in prison for their failure to pay a debt. But as we're going to see today, and as we're going to tell you, it's not always so cut and dry. What you've got to do, and what we're going to show you now, is an effort to try and get you to relax your understanding or conception of what a debt is. Because the key to understanding the instances and the circumstances in which people can be imprisoned, or at least threatened with imprisonment for their failure to pay a debt, arise out of forms of obligations that aren't conventional loans, aren't real estate mortgages, aren't car title loans, aren't necessarily credit card debts that they can't pay back. They arise out of common transactions that every American engages in today, which may not at the time seem to be the creation of a debt. So watch this video and understand.
I decided to come to the pawn shop today to sell my rare 1861 double eagle $20 gold piece. I took this coin for collateral against the guy skipping court, and he did skip court. Now I got to pay 50,000 bucks, so I'm hoping it'll make a dent in the $50,000 that I owe on this bond.
The U.S. Mint started making these coins in 1849, and they continue to make them for over 80 years. This is uncirculated, mint state. This is a very expensive coin. The reason this one is worth so much money is because this was a really low mintage year. I'd like someone to look at it who just knows a little bit more than me.
Sure.
When we had the 1849 gold rush, America had a substantial gold supply. They started issuing the $20 gold piece. Up till then, they only had the $10 gold piece, so that's why they call it a double eagle versus a eagle.
What grade do you think it is?
Looks very high grade off the cuff, very, very minor scratches on the whole coin, good body, very slight wear. This would minimally be worth $40,000.
Okay, thanks a lot, Andrew. I really appreciate it. How much you want for it?
34, you got a deal.
What do you think?
I'll go for it. What the hell?
All right, 34,000.
Fantastic.
The point in showing you that video is that looks like a simple sale transaction between one person in a pawn shop. Might even be considered a secured loan by the pawn shop to the person pawning the item. But if you look deeper, you consider the different steps that led to that transaction. A guy gave it to his bail bondsman as security for his appearance in court, failed to do it. Where did that guy get the coin? Well, there's backstories to all of these transactions that could ultimately lead that pawn shop to become an unsecured creditor and have to resort to the threat of imprisoning somebody, potentially, for collection of the $34,000 that they just paid for that gold coin. So keep those flexible boundaries on what you conceive as debt in mind as we talk to you today. We'll get back to the pawn shop example later in the presentation. I'm going to turn it back over to Harrison to talk about the first step that a creditor should take before it ever even files suit in court pursuing collection. So Harrison.
And so, indeed, contrary to the popular notion that imprisonment for debt is not possible, there is a statutory provision and a process that allows debtors to be imprisoned solely for debts after the judgment has been issued. And this statute, known as body execution or execution of the person, allows this process to be used in 5 situations, where the first 3 you see here are where a judgment debtor is able to bring the action to enforce the debt when these situations have happened. So notice the contractual prohibition note here too is explicit, just like in the Constitution in North Carolina. So essentially, when anytime there's some kind of malfeasance going on, where the debtor has harmed the creditor in some way that's willful and wanton or malicious, this remedy is possible. Also of note is that attorneys are also subject to this theoretically if they fail to pay a fine or a penalty that's imposed for the reasons that you can see on the screen. Additionally, if the debtor has the private property of the creditor and hides it for the sole purpose of avoiding the judgment, this remedy is permissible. And the final 2 possibilities for this you see are not so limited to these kind of debtors. Essentially, the fraud exception is one possibility, and again, that's an explicit cutout from the constitutional prohibition in North Carolina. Additionally, when the defendant has removed or disposed of his property, or is about to do so, the court is able to order the arrest of the debtor. And you notice that the creditor shall include now the dependent spouse and minor children, and that's an important and commonly used situation in which this occurs. So, in order to avail yourself of the statute as a creditor, the easiest way to do that is to think about it first things first, to include in the complaint facts that show that this situation is one of the 5 permissible options for the debtor to be imprisoned. This way you avoid the problems associated with things we'll talk about later, because this often arises in situations where the debtor is not responsive and not likely to show up. So in this situation, if you include it in the complaint, a default judgment is likely to be sufficient, along with additional findings that I'll mention in a minute, in order to have the person arrested. Alternatively, the process for arresting the debtor in a pre-judgment situation can be used to serve an order for the arrest of the debtor. And that requires the creditor making an affidavit to the court after litigation has begun, suggesting good cause to arrest the debtor. Also, in this situation, the defendant, or the plaintiff rather, has to issue a bond as security against any possible damages that the debtor faces if imprisoned. Notice that situation is avoided if you include it in the complaint. And finally, service and arrest by the sheriff follows from this order for arrest. So this is possible where, again, one of the 5 possible areas has happened. You're in that situation in the body execution arena, we'll say. The execution, you have to levy an execution against his property. This is important because this is not a remedy of first resort. Rather, imprisoning the debtor is a remedy of last resort. So the sheriff has to actually try execution and has to be unsuccessful in order for this to happen. And also you have one of the situations we mentioned before that allows it into this area. The order of arrest is served or the complaint contains sufficient facts that permit the arrest. And finally, the court must issue findings that suggest that the debtor is about to flee the jurisdiction, has concealed or diverted assets and fraud of his creditors, or will do so unless immediately detained. And the importance of this cannot be overstated. This finding of immediacy is crucial to this process being enabled. In fact, when this process was approved by the Supreme Court in the late 1970s, but the only real opinion was a district court, and they suggested that this was necessary in order for the statute to be valid under the U.S. Constitution as having an immediate harm to the creditor. Okay, so we'll consider some situations in which this has been an issue. And again, it's not that common, and you can definitely tell the courts are sort of unsure about what they have to do in this situation. So in that case that was eventually approved by the Supreme Court, the plaintiff hired an auto mechanic to fix his vehicle, to soup it up. He was a race car driver. However, the mechanic decided that this wasn't going to be good, and he basically chopped the car and sold it off for parts. So the plaintiff's car that was worth $6,000 at the time in the early 70s was worth about $200 after the defendant was done with it. The defendant then failed to pay, claimed that he was indigent, but it was not ever before the court, and the court really didn't believe him anyway. So he gets a judgment, and the mechanic flees to Florida, and he finally comes back, and the order for arrest is served on him. And the court, they found that this was permissible because there was damage to the plaintiff, and even though the specific finding wasn't that the mechanic was fleeing to avoid this judgment, because the mechanic had also been passing bad checks, it was sufficient rather that there was some finding that he was likely to leave or had left in the past that allowed his imprisonment. And in this case, they eventually were paid after the defendant spent 49 days in jail for the debt. In the second example you see up there, the defendant hijacked a beer truck and essentially they had a judgment against him for the cost and the damages that he caused when he did that. But there, the court overturned the order for arrest and suggested that in order for the order for arrest to issue, the finding has to be specific as to one of those 3 situations, whether he's about to flee, has wrongfully diverted the assets or will do so unless immediately detained. And in that case, the trial court found that the defendant was going to file bankruptcy in order to absolve himself, and that was not sufficient. That was not sufficient for the arrest of the debtor. So it's rather uncommon, and the courts are very unclear about what is actually required. We do know if the creditor is going to avail himself of this, that it's best that in the court's findings, it specifically says one of the statutory requirements. Using the statutory language indeed would be best itself. There are other risks from the creditors face potentially in this situation. Malicious prosecution could exist. Courts have found that the fact that a court has found good cause in order to order the arrest or to approve limits malicious prosecution later. But if there's some kind of fraud the creditor commits in suggesting the good cause, then that's certainly a possibility, and the plaintiff could become the defendant in the later action and be found liable in tort. Second is increased cost. In order for the defendant to be arrested, like other civil matters where the police are involved, the costs have to be paid by the plaintiff. There is a specific statute that says that the creditor in this situation has to pay for the debtor to be imprisoned. That statute hasn't been cited since 1868, and it seems quite archaic, but you're likely to have to still pay the costs in this situation. Another problem with increased costs is the judicial unfamiliarity with the statute, and we've seen that in the beer truck case, for example, that the order was issued and it was later overturned. So the creditor was basically left holding nothing and having to pay his attorneys to go to the appellate level to resolve the matter, simply because the findings weren't sufficient that the court issued in order for the court's remedy to happen. And it's a product of the few cases and the complexity of the statute at hand. Additionally, in the age of the internet, debtors who are arrested have a great ability to publicize their arrest, and because of the popular perception that it's illegal still, it's not likely to be good for business as a creditor, which is something we'll talk about later. So now, Miles, we're going to discuss the four. Elliott's going to talk about the four common law areas.
Thank you, Harrison. In North Carolina, there's four major common law exceptions to the constitutional rule against imprisonment for debt. The first is fraud. The second is the willful failure to pay state taxes. The third is restitution as a condition to the reduction of a sentence. And specifically in that one, we're going to try and get rid of some of those problems that Harrison just mentioned. The fourth being willful disobedience of a court order, which Miles is going to address in great detail. The first, as I mentioned, is fraud. Fraud is specifically written into the Constitution of North Carolina as an exception to the rule against imprisonment for debt. So, if a debtor has not already been arrested and you allege that the debt was contracted fraudulently, it is possible, if you go through some of the procedures that Harrison talked about in the affidavit, to have this debtor arrested. Now, again, these facts are sufficient to support an order of arrest. However, you've got to prove the elements of fraud, and this isn't as easy as it seems. The elements of fraud are: there must be a definite and specific representation which is materially false, made with knowledge of its falsity, or in culpable ignorance of the truth and with fraudulent intent. And this representation must be reasonably relied on by the other party to his damage. The real problem with these elements is that it sort of creates a catch-22 in the statute. If those elements could easily be proven, that debtor would already be in jail. If they are not easily proven, you're stuck with trying to prove it to get the debtor in jail. A lot of the problems arise up in that Nunn v. Smith case that I have cited. It's a defendant goes into basically a local business, writes 2 checks, totaled about $500. Bad checks, insufficient funds. Owner's not happy. Owner wants to get his money back. So owner gets his money back with a judgment lien. Judgment lien's not being paid. That's a problem for the owner. Owner wants his money. Says, well, okay, insufficient funds. That's fraudulent. It's fraudulent checks. You never had the money, and I want punitive damages. But in court, the judge tells the owner it's not good enough that you just show that this person had insufficient funds. They had to know they had insufficient funds to get them in prison. The owner's got a judgment lien that's more or less worthless if the person's not paying it, and you can't prove the elements of fraud. You've got to make sure this is in the affidavit. You've got to make sure you can prove the elements. The second one is, we're going to mention it because it's important to mention as an exception, as an established exception, is state taxes. But for a creditor's attorney, it's not going to be as helpful most of the time because it deals with state taxes. Ordinarily, mere non-payment of taxes is not going to get you thrown in jail, but if you're required by the SRA to pay taxes, and you don't do it, and you're willfully disobeying an order, you can be guilty of a misdemeanor. This is because of a long established common law exception that taxes are not contractual obligations. Taxes are basically obligations of any state taxpayer, so there's no contractual relationship there, and imprisonment for debt only applies to contractual obligations. Therefore, it sort of carves out its own exception in North Carolina, and it's a widely accepted common law exception to the rule against imprisonment for debt. So any attorneys working for state tax services, this could be very helpful. A creditor's attorney, not so much. Now, this one's fun. Restitution. This other parts of this, other ways to get around the rule of imprisonment for debt have involved getting someone in jail. Restitution sort of involves getting them out and getting them to pay you. Basically, you can get a probationary judgment requiring restitution. Defendant A commits a crime, goes to jail. Well, he's not making money in jail. So the creditor says, well, let's bring him out. We're going to reduce his sentence. And since we're reducing his sentence, he's going to have to pay us as part of his probation. This is absolutely constitutional. This is absolutely allowed as long as the criminal act is related, directly related to the crime in which for which the debtor was convicted. Now, the statute says that debtors may be required to make restitution to an aggrieved party or parties who shall be named by the court for the damage or loss caused by the debtor defendant arising out of his offense. Now, a lot of legalese thrown around in this statute, and the courts have fortunately interpreted it quite broadly. And so now we're back at the pawn shop. We've got a pawn shop creditor and a debtor who comes in with some silver. The video was gold coins, but we're going to change it to silver here. Comes in with silver coins, says, I want to pawn this silver. Now, any diligent pawn shop fan knows that the difference between pawning and selling is this. If you sell the silver, It's a transaction. I give you silver, you give me money. The silver is now yours, the money is now mine. But if you pawn it, it's a loan based on collateral. The silver is the collateral for the loan. I'm going to pay you back. If I don't pay you back within a certain amount of time, I'm signing something that says you get to keep what I gave you. But let's say the silver might not have been for the defendant or the debtor here. Let's say the debtor stole the silver from his mother while she was on vacation. Pawns it at the pawn shop. The mother comes back, thinks, I'm missing something. My deadbeat alcoholic son probably stole some jewelry from me. I'm going to get him arrested. He admits to pawning it. She gets the silver back because it's hers. He goes to jail because he broke the law for convicted of larceny. The pawn shop is stuck. They've lost the money. And so here we have a third-party creditor. And even though the debtor's crime, or the debt is directly related to the crime, the debtor isn't as much related because he's convicted of larceny, stealing. But he hasn't been convicted of pawning it. So the question arises around third-party creditors. Can a third-party creditor get, as part of a judgment, a sentence reduction based on restitution to them? I guess the studio audience and the lawyers at home can think about this for a second until I show them the answer. And the answer is, of course, yes, they can. It's directly related to the crime that the debtor defendant committed. And this is very fortunate for third-party creditors. The real problem here involves a little speculation. And I've talked to attorneys about it. Well, at first you talk to attorneys and say, no, you can't do any imprisonment for debt. That's unconstitutional. You absolutely can't do it. So, well, actually, yes, you can, and you've probably done it, especially district attorneys or other prosecutors or defense attorneys looking to get sentence reductions. And I give them the pawn shop scenario. They say, oh, okay, well, that makes sense. I said, okay. I give them this hypothetical. What if a third-party creditor is a bank who gives a small business loan to a local mom-and-pop shop? Local mom-and-pop shop gets robbed, thousands of dollars. Defendant goes to jail for robbing them. They go bankrupt. The crime was committed against the store, but the bank wants the restitution. So the bank's attorneys, can they go to the district attorney? Can they say, listen, we need to reduce this guy's sentence so we can get our money back? There's no case law here that I found in North Carolina. However, every attorney I've talked to says this is a logical step. It's the same circumstances except you substitute a loan and bank instead of pawn shop and pawn. And so just substituting these words, speculation is you can probably do it, and it's probably worth taking a shot, even though there's no appeals court or Supreme Court state law that we found in research on the issue. A different issue arises if an insurance company instead of a bank comes up. Say an insurance company insures an automobile dealership. Now, the dealership gets a van stolen off the lot, high-speed chase down the interstate, wrecks, totals the van. The driver of the van who robbed the dealership's going to jail, and they do. But it was insured. So if the van was worth $10,000, the automobile dealership is going to get $9,900 of those dollars back because it's insured. The insurance company says, well, wait, we're like a third-party creditor here. We had to pay the automobile dealership. We want our money back. Can't do it. And I'll tell you why. It's written specifically in the statute. Specifically in the statute, it is written against insurance companies, and it was upheld as constitutional. There was a constitutional argument made against it that it created a specific class of criminals. They said, no, this is fine, because the insurance company would be double dipping. They take part of it. In the insurance business, there's inherent risk. You're insuring things, you're getting paid premiums, deductibles, etc. That's your business. So if you are a thief watching this, make sure you steal things that are insured, because it will significantly lower the amount you have to pay on restitution to get out of jail. Now, the practicality of it is, it's not a lot of big debts. If there's millions of dollars out there, this isn't usually the thing you're going to use. But hundreds and thousands of dollars, we've seen it in the case law. It can be done, especially with this restitution thing. And with the restitution, you don't have to go out and try to get the order to imprison it. The DA is already going to put the guy in jail for you. You don't have to worry about this public perception, because really the restitution is getting the guy out of jail, not putting him in. And so it kind of gets away from some of those risks and some of the bad publicity that you can get putting people in jail. The other thing, when I talk to prosecutors, that I thought was really neat, they say, well, a lot of times if someone steals and they owe someone money, well, a lot of times what we do, you get them convicted. You bring them in the office, or you bring the attorney in the office and say, look, we're gonna suspend a sentencing hearing for about 6 months. See how much he can get paid back in 6 months. If he gets a lot paid back in 6 months, he might have a more lenient sentence. If he doesn't get a lot paid back in 6 months, the sentence is gonna be a lot harsher. So for creditors' attorneys, you might want to take the DA out to lunch right before that sentencing meeting and say, listen, we want our money back. We're going to save you a lot of paperwork here. Just get that restitution paid before he goes to jail. DAs comply with this, and from what I've understood, this happens all the time. All the time. But just not with creditors' attorneys, mostly because they think they can't do it. The fourth one is the willful disobedience of a court order, which Miles is going to address.
Thank you, Elliott. So the last topic we're going to cover today is the use of a contempt order by a judge to throw a debtor in prison. As Elliott mentioned, this requires the debtor's disobedience of a court order. This one's a little different than the mechanisms for imprisonment that Elliott and Harrison have talked about, because it's much more broadly applicable to just about any obligation of one party to another. It doesn't have to arise out of financial transaction between two parties originally, so it's not a conventional debt that we're talking about, and this goes back to our request of you to broaden the scope of your concept of what debt can be. To give you some context for where we are before we get to the contempt order, we're all familiar with the filing of a claim that results in a judgment against one party. You then have a judgment creditor and a judgment debtor. Their respective obligations have been boiled down into a monetary obligation. That's essentially a debt. Again, that didn't have to start out as a monetary obligation, but now, by virtue of the judgment, it's become a monetary obligation. Next step to enforcing that judgment is execution. By virtue of the state statutes, sheriff goes out, collects the debtor's assets, and pays the judgment creditor. When contempt becomes an issue is when that execution is returned unsatisfied. What's the creditor to do then? If the execution was unsuccessful, it remains unpaid, is it going to sit around and wait for the creditor or the debtor, to make more money? That's one option. But if it wants to get a little more aggressive, it thinks that the debtor has assets that it ought to be putting towards this debt, that's where contempt and the threat of arrest or actual arrest can come into play. So Chapter 1, Article 31 of the North Carolina General Statutes, using North Carolina as our example today again, governs all of the supplemental proceedings that a creditor can use to try and collect on that debt. The particular section that gives the judge in the case the authority to find the debtor in contempt of court is section 368. As you can see, it gives the judge the discretionary authority to find a debtor in contempt for violation of an order. So very simply, keep these steps in mind as I walk through the various orders that a judge can issue that can be violated by the debtor. This requires the creditor's attorney to file a motion seeking a particular order, one of the ones that we're going to talk about. It requires then the debtor to violate that order, and only then can the creditor's attorney go back, seek a motion for contempt or file a motion for contempt, and the judge, again in his discretion, issue a warrant for arrest, finding the debtor in contempt for violation of that order. So there's really two categories of orders that a judge can issue in the course of supplemental proceedings. If the judge finds upon affidavit of the creditor, his agent who went out searching for the debtor's assets, or the creditor's attorney, to the judge's satisfaction that the debtor has property that he is willfully withholding from execution, then the creditor can ask for the appearance of that debtor. The judge can order the debtor to appear and answer about the specific assets that he's withholding from execution. Section 362 appears to give the creditor a mandatory right within 3 years of the failed execution to have the court order the debtor to appear and answer about all of his property. This is a little more relaxed, and it is different from all the other orders in that it is a mandatory right of the creditor. It eliminates one step of the judge's discretion in moving this case forward for the creditor. The judge must, upon request of the creditor, order the debtor to appear in court. If the debtor, again, fails to appear as ordered under either of those two statutes, that failure to appear is violation of a court order that allows the creditor to go back and ask for a contempt finding from the judge under that broad section 368. The other category of orders fall under supplemental discovery methods available to the creditor. And there's really three subcategories of supplemental discovery available to the creditor. The first are simple written interrogatories, which are like any other interrogatory used in the course of litigation. Within 3 years of the failed execution, the creditor's attorney can serve on the debtor written questions, essentially asking about the debtor's property, ownership, location, amount, value, etc. The debtor has 30 days in which to respond to those interrogatories, likely because he's withholding some assets, not going to respond to those interrogatories. If he fails to do so within that 30-day period, again, that's still not enough to have the debtor arrested. You don't have an order from the court related to those interrogatories yet, so the creditor has to go back to the court, ask for or file a motion to compel response to those interrogatories. If the court agrees, it'll issue the order, and then the debtor has a shorter length of time in which to respond to the interrogatories, or in lieu of response, ask the court for an opportunity to appear for an oral hearing if it would rather just discuss the issue in court. The other two subcategories require the the creditor to show good cause that the judge should issue either one of these orders. Again, that's going to be related to proving that the debtor has assets that ought to be applied to the judgment, that it's somehow that aren't being found. The first is an order requiring the debtor to either produce documents related to the ownership of those assets, or actually produce the property itself in court for assessment by the court or actual application of the judgment. And the second is an order against the judgment debtor requiring the debtor to allow entry onto its property. That can be real or personal property, and that can be by the debtor or by the creditor himself, the creditor's agent, appraiser, somebody investigating the value of the property. So essentially, the scope of supplemental discovery is pretty broad. It gives the judge a lot of discretion in which he can either agree to issue the order requiring responses from the debtor if the creditor has proven that there's something out there that the debtor ought to respond with or to. And if the debtor continues to ignore these orders, that can lead to a contempt finding by the judge. A couple potential applications of these supplemental discovery methods. The first, increasingly common, involves the pursuit of a debtor's assets that it has hidden offshore. A judge, under its ability to order the production of documents demonstrating ownership or its ability to order production of the property itself, can force a debtor to go retrieve those assets, bring them back, and have them applied to the debt. The other involves the one type of failure to pay that is enough to result in a contempt finding. All these orders that we've talked about have been unrelated to or subsequent to the debtor's failure to pay. Failure to pay isn't enough generally to result in a contempt finding. But if the debtor owes the creditor because of a settlement agreement to which both parties agreed that was subject to a judicial order, and then the debtor willfully fails to pay, that failure to pay becomes a violation of the ordered settlement agreement. And that failure to pay can land the debtor in jail through a contempt finding. Important to remember, though, that if it's a settlement agreement that was not the subject of an order by the court, was just an extrajudicial settlement, it's not going to be enough if the debtor fails to pay under that agreement. So we talked to several attorneys about whether they've considered using this mechanism or any other to have the debtor imprisoned as a tool in their collection efforts. Almost to a person, they all said hadn't really considered it, largely because they didn't know it was allowed. The one field in which they did say they could imagine it being done is the use of the contempt tool, because it's a pretty, among all of these mechanisms, a pretty common tool. One attorney that we talked to did in fact report her personal experience with successful use of the contempt finding, contempt-based arrest to have a debt collected. So I'm going to walk you through the steps that were involved in that case to give you a very clear picture of how you get to the point of having a debtor arrested for contempt. The case in which this arose was actually a pro bono representation by the attorney. It involved a small nonprofit micro lender, religious organization that was making loans to rural small businesses to try and help its community. The debtor in that case took a small loan. Instead of applying it to the startup of a small business, she went to Disney World, misused the applications. That amounts to breach of contract. Obviously failed to repay the debt as required. Because this was a small nonprofit organization, it needed the money back. And so it decided to pursue all options available to it, including the pursuit of imprisonment. Step one, as we mentioned, the creditor's attorney had to obtain that default judgment against the debtor for breach of contract and failure to return the funds owed. The execution order was returned unsuccessful as required. Then we get to the supplemental proceedings that we talked about. The creditor drafted and served interrogatories on the debtor. Those were ignored again. The creditor's attorney then has to go back into court, file a motion to compel responses to the interrogatories, as we mentioned. And this, again, is the key step. The judge responded with an order to compel response to the interrogatories, and it's that order and the violation then by the debtor that gives rise to the judge's authority to issue a contempt finding. The motion, or the third time that the attorney returns to court is a motion for a contempt finding. And only then did the judge issue the contempt finding and issue the arrest warrant to the sheriff, who went out, began to arrest the debtor, who then at that point agreed to respond to the interrogatories and ultimately ended up paying the debt owed. The case highlights some of the practical difficulties in using contempt to have a debtor arrested. The first is you've got to find a judge who's willing to throw a debtor in prison simply for failure to pay a debt. As we've discussed, it's not a popular thing. Some judges, local judges who are elected, are not going to want to be seen as willing to imprison people simply because they can't pay their debts. It's not a popular thing to do. In this particular case, it was a fairly unique circumstance. You had a debtor who had taken a nonprofit organization's money and gone to Disney World. Pretty skeezy debtor, as debtors come. You have a particularly sympathetic creditor as well, a nonprofit religious organization trying to do good in its community, not a conventional creditor. So the judge was more than willing to help in that case, but that won't always be true. Contempt is uncommon for violation of judicial orders. In this particular case, the attorney reported that in open court, when she went back for the contempt finding, she had to walk the judge through the statutes giving the judge authority to issue that contempt finding simply for failure to respond to interrogatories. Again, willing judge, willing to cooperate, but creditors, attorneys should be prepared for having to do this. You've got to be more educated than the judge in certain circumstances. And finally, the creditor's attorney reported to us that the sheriff in this case was friends with the debtor and went back 3 to 4 times to try and urge the debtor to respond, to show up in court, to avoid arrest. And only when he actually made good on his obligation to place the debtor under arrest did action come. Sheriffs in some states are elected local officials as well. They don't want to be seen as people going out arresting debtors simply because they can't pay. They also have other problems to deal with. Popular accounts these days from law enforcement officials indicate they don't want to be forced to put resources towards putting people in jail simply for failure to pay a debt when they've got to deal with violent crimes. The other couple of issues that came up in the case, it obviously was time consuming for the attorney. It takes a while for the creditor to get action. In this case, as we've mentioned, the creditor's attorney had to go back to court 3 different times, and there's intervals of time that have to pass between each one of those steps. It's costly. In this case, it was a pro bono representation, so it did not matter to the creditor that it would have cost money to a normal creditor in the course of business. I want to give you a few more nuances of the contempt-based arrest mechanism. Contempt can be a risk to third parties who are somehow related to the judgment debtor if they violate a court order that comes out of a creditor's collection attempts. So attorneys representing third parties ought to be well aware that any time their clients are served with orders, the clients need to respond, but sometimes clients don't understand that. There are various orders that the court can issue against third parties under this supplemental proceedings statutes. The first involves a prohibition order preventing third parties from transferring a judgment debtor's property that it happens to possess or money that it owes to the debtor. It'll order the third party not to transfer those funds or that property until resolution of the debt is made. The other involves the obligation or the order of the court to have the third party appear, just as we talked about with the debtor himself. The court can order a third party who has possession of a debtor's property to show up in court. If you fail to do that, you can be subject to contempt. Lastly, and somewhat interestingly, this is general garnishment type action. If a third party does indeed hold property of the debtor, the court can order that property applied to the debt. And if the party holding the debtor's property disagrees, doesn't want to, it might resist, but that's a violation of the court order and can result in contempt. An interesting nuance that the courts have kind of pushed back against creditors in North Carolina under this statute is creditors have traditionally pursued earnings of judgment debtors that the debtor earns from a job. There's an exemption under this statute that precludes the reach of creditors to earnings that are necessary for the debtor's support of his family. Courts have broadly expanded that exemption to apply to all future earnings of a debtor, even if those earnings clearly exceed the amount necessary for familial support. Pretty harsh result. The court went on to say, in this case, Harris versus Henson, that even when a debtor is obviously willfully misapplying funds that it's earning through its job, not for its family support, and those funds are in excess of what's necessary, too bad the exemption applies to those as well. I want to raise the one general defense available to any party subject to a contempt finding for violation of an order. All it has to do is show up and demonstrate that it was impossible for it to comply with the order. In the case of appearing before a court, that's going to be hard to prove. If you didn't appear, you're going to have to prove that you were detained somehow and unable to show up that day. But creditors' attorneys should be aware that this may be a very easy defense to their use of this contempt-based arrest. Contempt in federal courts, the state limits on imprisonment for debt apply to federal courts. So where a state court could issue a contempt finding, so could the federal court. But where a state has limited contempt, for example, in the earnings exemption, the federal court would be bound by that exemption as well. So again, summary of some of the reasons that imprisonment for debt is rarely used, and particularly this contempt-based arrest. A lot of people think it's just prohibited. Bad perception, cost, expense, judicial system's unfamiliar with it. But always remember, we've talked about North Carolina law today. It's going to vary by jurisdiction, so be aware that you should always understand that the jurisdiction that you're practicing in may have different rules than these. I'll turn it back over to Harrison to close. Thank you very much.
All right, so I think we've seen that there is some considerable confusion surrounding this area of law, and it's not easy it's easy rather to see why. This remedy is likely to make the debtor pay immediately. It's very powerful for a creditor, so it's not likely to ever be appealed because, first of all, the debtor is a debtor, so who hasn't paid is likely not to have really funds available and the time to appeal. And second, the situation most often arises when the debtor simply fails to respond, and then the debt is paid, or the debt can never be paid. Regardless of the situation, there are very few appellate level cases dealing with the situation, and those that are deal with the situation they fudge the lines between the situations and fail to draw crucial distinctions often. But it's understandable because they too are under the impression, like all of us are generally, that this is a relic of times gone by and is no longer possible today in our society. That's why it's very important for creditors' attorneys to be knowledgeable in this area, to be able to walk through and explain the concepts clearly to any judge in order to use it. Because by being very knowledgeable, you're likely to direct the proceedings in your favor, given the relative ignorance on the subject for most parties. And finally, this situation is fluid though. The last couple of years and the Great Recession has brought new interest in this area. And there are several press reports about modern debtors' prisons, and Miles is going to pass out a recent article from the Wall Street Journal discussing this. There have been several since the last 3 or 4 years talking about the return of debt prisons and generally lamenting how the state of modern America, that we could throw people in jail for debt. However, I think it's important to realize though that these cases do not mention the reason that the debtor was imprisoned, namely the debtor's failure to appear. Instead, the sympathetic debtor is portrayed as kind of railroaded by the mean creditor. So that being said, it's likely that there's going to be some kind of action in the future to limit this, especially if it continues in this manner. The FTC is considering actions to amend various federal laws about protecting debtors from this kind of imprisonment. And state legislators and attorney generals are also threatening responses, either through legislation or the regulatory process. Indeed, in certain states, attorney generals have discussed their willingness to use the regulatory process in order to eliminate debtors and just basically, revoke the license of debt collectors who use these methods. But that being said, it's really difficult to say what they really can do, because failure to appear, failure to respond to the court is something that's very serious, and that's how most of these situations arise. So I guess as a takeaway for all debtors out there, if you ever are told to go to court, you should appear.